side and be seated and remain quiet, please.
Okay, good morning. Court is back in session. We have all of the jurors present, the lawyers are present, the defendant is present. I have not been presented with any type of pleading, so I'm going to assume everyone is ready to rock and roll.
Your Honor, before we get started, before we rock and roll, I just don't know who the defense is calling next,
Okay?
but I just want to confirm on the record that the defense has spoken to their witness or witnesses that they will abide by this court's prior ruling regarding hearsay testimony not coming in between Heather Combs and Brenda Woodard.
Okay? I assume you've done that?
Yes, ma'am.
Okay, Mr. Secor, are you questioning the witness?
No, Judge, before we bring in the jury, and if I could please sit, just because I'm looking at that.
No problem.
We would like to enter some records, go ahead and enter them into evidence now. The state has no objection. We
Okay.
are aware, so if we could go through those quickly.
Sure.
I do have an objection,
Okay.
and I think it's one thing. You want to go through one by one?
Just go ahead and read it off like you're entering, and I'll ask the state if they have an objection to each one like we do in front of the jury, okay?
Sure, Judge. The first one is marked as D1Z, and those are tomorrow's rainbow medical records. Or
D1Z, you mean 1Z?
Yeah, well.
Okay,
The
I
bad
thought,
ones,
I
yeah.
wasn't sure if you created a new numbering system.
No.
All right, 1Z, state,
No objection.
all right, 1Z without objection will be entered as 87.
2B as in boy, Judge. And those are the Dollar Tree employment records.
No objection.
Okay, without objection, 2B will be received as defense 88.
The next one is 2E as in echo, and these are Medicare information from Social Security Administration records.
I asked to see those, and I don't think I've seen them yet.
I'm sorry.
Can you skip this one for a second?
Sure.
Sure. Judge, the next one is 2F,
Did you want to say these?
and those are Social Security Administration records that are not the Medicare records.
I wanted a moment to look at those.
Oh, both of them? I'm sorry, Mr. Marquez.
That's okay, so we'll pass on 2E and F.
Yes, ma'am. So 2J, and that's Dr. Musel's medical records.
No objection.
2J without objection will be received as 91.
The next would be 2P as in Paul, and that's the Department of Children and Family call transcript.
All right, Judge, we object to this. This is just a hearsay transcript of it comes out as an anonymous person calling in an abuse hotline.
Like an abuse report.
It's an abuse report. Now, the defense knows who this is and can call this witness. It's a person who's given a statement saying they've called. So this is an out-of-court statement that's just been transcribed.
Okay, even if you call the witness, you can't ask them about an abuse report. It's actually a misdemeanor if you were to do that. Under chapter 39. So I agree, this is not admissible by itself or through the witness.
Yes, yeah. Oh, I'm sorry, just give me.
All right, so 2P, I'm sustaining the state's objection.
Okay, Judge, the next one is 2Q, and this is the Department of Children and Family Investigative Summary. It is their report done on an incident regarding Mr. Cruz.
Does it have the reportee?
Say it one more.
Does it have the person reported? First of all, state, is there any objection?
I don't know of any confidentiality confidentiality. It just says confidential, but it's no objection by us.
Okay, without objection, 2Q will be received as 92.
2B as in.
Be careful, because I know that not everybody in here practices independency or has familiarity with dependency, but please be very careful about asking people about abuse reports or anything to that effect. That has to be approved in advance by the judge who was presiding over the case. There's a whole bunch of rules, so please, Mr. Seco, are you going to be questioning the witness?
No, ma'am, but I understand what you're saying.
Oh, why are you standing there?
To help me because I'm.
Oh, okay, who's questioning this witness? Hello?
Which witness?
Which
Your
witness?
next witness.
These don't have anything to do with it.
Yeah, we're just entering them.
These are
They're
just
not
records, we're
used.
just doing it now.
So is it a secret who's gonna be questioning your next witness? Because I'm gonna find out in like 3 minutes.
No.
Who was doing it?
If the records don't relate, but if we call the witness, it will be me. I'm assuming you're talking about that.
Who is your next witness, and when are they being called, and which attorney is going to question them? Let me be clear, if I wasn't before. Because if these don't have anything to do with your next witness, then why are we having the jury wait outside right now?
Just because we were trying to move everything in, because in terms of timing, we do it now.
In terms of timing, it would be much better to do it during the lunch break, when the jury needs longer than you all. So we'll go ahead and pass on this. Let's bring the jury in, please.
Your Honor,
Yes?
at this time, the defense rests.
Other than putting in our records.
We're not playing chess. I mean, will you please take the jury back in? Thank you. All right, go ahead and put in your records.
2B, Nicholas Cruz Henderson, episode 1 record.
Let me just stop. State, are you gonna have anything ready for today?
No.
The
We're
defense last told
expecting,
us there was 80 witnesses.
we're waiting for 40 more witnesses.
I just wanna say, this is the most uncalled for, unprofessional way to try a case. You all knew about this, and even if you didn't make your decision till this morning, to have 22 people plus all of this staff and every attorney march into court, be waiting as if it's some kind of game. Now I have to send them home. The state's not ready. They're not gonna have a witness ready. We have another day wasted. I honestly, I have never experienced a level of unprofessionalism in my career. It's unbelievable.
So Judge, if we had any pretrial matters, you asked us to be here at 9:15. We were here at 9:15 to discuss pretrial matters. I have been practicing in this county for 22 years.
You know what, I don't wanna hear it. I don't wanna hear
Well,
it.
Judge, you're insulting me on the record in front of my client, and I believe that I should be able to
Okay,
defend myself.
you can do that later, you can make your record later, but you've been insulting me the entire trial. So blatantly, taking your headphones off, arguing with me, storming out, coming late intentionally if you don't like my rulings. So quite frankly, this has been long overdue. So please be seated, you can receive the evidence, I will receive the evidence, and then you can put whatever you want on the record at the end. Go ahead.
2B, which is Nicholas Cruz Henderson records, episode 1.
I'm sorry?
Episode 1, Henderson records for Nicholas Cruz.
2V,
I'm sorry, 2B is the victim.
is there any objection to 2V as in Victor?
Sorry, what was that again, please?
To the,
I can't read.
oh, Henderson Behavioral Health, episode 1.
That's fine.
Without objection, 2V will be received as 93.
2W, Henderson records, episode 2.
Is there any objection to 2W?
No, Your Honor.
2W without objection will be received as 94.
2X, Henderson records, episode 3.
Is there any objection to 2X?
No, Your Honor.
2X will be received as 95.
3A, Camelot Community Care records.
Is there any objection to 3A?
No, Your Honor.
3A will be received as 96.
3W, Henderson records of Zachary Cruz.
No objection.
3W without objection will be received as 97.
3X, Lutheran Services records for the Littman Shelter for Zachary Cruz.
And you're certain that none of these have any references to abuse reports or anything? Because a lot of times kids are sent to Littman as a result of that.
That was not the list.
Okay, but you've reviewed them and there's nothing about collar or anything like that? I don't want to get anyone into trouble, including myself. All right, is there any objection to 3X?
No, Your Honor.
3X will be received as 98.
And then 4S is in Sam, Nicholas Cruz disciplinary action records.
So, Your Honor, with this particular record, this is pertaining to the attack on Sergeant Beltran at the jail. Now, in this record,
I thought you did school records.
No, disciplinary
Oh,
action records, I didn't
I
make it clear
assumed
which
that
ones.
that was a school thing. Okay, sorry, go
so
ahead.
on this record, it says that the defendant invoked his Miranda rights. And ordinarily, that might be an issue. And so that the record is clear that this is a trial strategy by the defense, and the defendant himself agrees, if he asks for that to be left out, it would be left out because it's telling the jury that he invoked a constitutional right.
Right.
And he has the right not to have that before this jury.
I understand.
And so in this record, that's what it says.
Okay, have you reviewed this with your client?
Yes, ma'am, I have a waiver comment.
We have a waiver. This thing has to see that, Casey. I don't think.
Just let me read it really quick.
Okay.
All right, do you want to show that to the state,
Yes, ma'am.
please? Will you let them know it's gonna be a while, but it's gonna be an early day? Please, thank you. Good morning. Thank you. We have COVID security.
Your Honor, I appreciate the defense did this waiver. It does not explicitly refer to the Miranda warnings on the document. The waiver is fine if the court will just require that he knowingly, intelligently is understanding that the jury is going to know that he invoked a constitutional right that
Okay.
he doesn't need to.
Mr. Cruz, please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can put your hand down. Sir, it's my understanding that there's a reference in this document from the jail, the disciplinary records, that indicates you invoked your Miranda rights. Was that, oh, that wasn't with Detective Curcio, that was with, regarding the jail incident. When they asked to take a statement, that is something that the jury at this point would not hear. Actually, because it relates to the jail incident, they would never hear that. They're not entitled to hear that. That's a right that you can invoke, and nobody's allowed to mention it, and if they did, it would be a big issue. So, are you waiving, we can take that part out of the report if you so choose. Are you waiving the right to redact the fact that you invoked your Miranda warnings?
Yes, ma'am.
Okay, have you had enough time to speak to your lawyers about that decision?
Yes, ma'am.
And has anyone pressured or coerced you into making that decision?
No, ma'am.
Okay, I'm gonna find that the defendant is making a knowing, intelligent, and voluntary waiver of his right to have the jury not hear or consider the fact that his Miranda warnings were invoked with regard to the jail incident. So 4S, without objection, will be received as 99. That's all of Okay, so we skipped,
Oh, wait, social security. So 2E would be the Medicare social security records.
No objection.
okay, 2E will be received as 100, defense 100 without objection. We also skipped, I believe, 2F. Yes. Oh, I skipped the actual number too, you're right, thank you. I stand corrected, thank you, Madam Clerk. 2E will be received as 89.
And then the social security administration records that do not include the Medicare information.
2F,
Yes.
state, have you had a chance to review 2F?
Yes.
And do you have an objection?
No.
All right, 2F will be received as Defense Composite Exhibit 90. So there's 99 total. Just to double check, please.
Yes, ma'am.
Judge, while we're moving stuff in,
Okay,
the defense has already seen, this is two photographs that were used in the Finney Broward perpetuation. but
Okay.
We never actually moved them in.
okay.
Defense has seen it, so say we use 26E and 26F for identification into evidence.
So Defense, do you have any objection?
No, ma'am.
No, who's the point person? 26E. Do you know what number we're on? Excuse me? 26E will be received as states 488, and 26F for identification will be received without objection as, someone did say no objection.
Yes, ma'am, I did.
Thank you, 489.
Your Honor, the state is going to ask for an extended colloquy of the defendant. We're going to need a few minutes to get together the list of defense witnesses that they're not calling
Okay,
or could call, so that there's no question that it's a knowing and intelligent decision. The defendant has no objections to this strategy.
okay.
Um,
So we'll just take a recess and you all can let me know when you're ready. And also, while you're doing that, if you can please try to figure out when you can, I assume you're putting on a rebuttal. I mean, I don't know that for sure, but I saw you had a doctor here yesterday. Do you have any idea when you can start that?
No, I mean, we gotta start thinking about it.
We'll make some phone calls.
Okay, so, and the defense needs to rest in front of the jury, but I think it's important that I colloquy Mr. Cruz before they do that. So let's take, what do you think, 30 minutes? 45 minutes?
Your Honor, I think it's gonna take, some time. The defense filed a witness list. They told the court that they were gonna be calling 80 witnesses. So we have to go through the witness list, we have to go through, the defense is gonna have to go through and put together the 80 witnesses that they said that they were going to be calling.
Okay,
It has to be carefully done, this has to be meticulous.
okay, so,
I don't think, what I'm saying is, Judge, I don't think that this can be done in 30 minutes.
no problem.
I don't think it's reasonable to give the jurors say to them to be back in 30 minutes.
No problem. So here's my next question. I would like to be able, before I excuse them, to tell them when they're gonna have to be back. Because they're gonna need, I give them at the end of each week written a documentation for their employers. So I'm gonna have to do that, and I just hate releasing them without some of, I don't remember if any of the ones that are actually serving were ones that were sometimes hard to get a hold of, but I really would like to be able to give them something in writing of when they need to come back. So at least if you all could,
Can I confer with my colleagues, Your Honor?
sure. In other words, Ms. McCann, if you all need 30 minutes to get this part together, then I can call them in, have the defense rest, I can excuse the jurors, and I can colloquy Mr. Cruz after I excuse the jurors. Do you see what I'm saying?
I do, Your
And then if
Honor.
I'm not satisfied with the colloquy, we can always deal with that later, but rather than having them sit back there until you can get all of that accomplished, which might be this afternoon.
Well, for planning purposes, Your Honor.
Okay.
And this is based upon, just finding this out because, we were told last night that there were 2 witnesses for today. And that's what we were planning on and that's what we prepared for. And went through this morning asking if they had advised their witnesses about, abiding by this court's order, and they said yes, with no indication that they were resting. And that's fine if that's their strategy, that's fine, but we just have to put that on the record. But, Your Honor, for purposes of the state now planning the rebuttal, which is substantial, we would like to have a break so that we can inform, so that we can put together the colloquy that needs to be conducted for the defendant, inform the jury, or let the defendant rest in front of the jury, let the state contact our rebuttal witnesses, put it together, and we would like to resume, if possible, Your Honor, on Monday, September 26th. Oh, we're off the 26th, I think I'm sorry, Your Honor, it's a holiday, Tuesday the 27th.
I need that much time.
Yes.
The reason I want the defense to rest in front of the jurors is because I would like to be able to explain to them why I now have to, I don't know if you all are aware, but we're running out of time. We have a pregnant juror, very pregnant. We also have a few of them with family members with COVID, and I'm worried that.
Well, Your Honor, even if we resumed at the end of next week, which would be Thursday the 22nd, we would still be out of court on Monday the 26th. And what the state is anticipating, it would take at least a week for us to put on our case in rebuttal. So no matter what, Your Honor, we look like we're going into the last week of September.
Okay.
So if we could start on the 27th, we could get it done and not ask for more time.
Gabe's not here?
Your Honor, if we're able to contact our witnesses and get them in earlier, we can start earlier.
Okay.
Realizing that it's a Jewish holiday on the 26th of September, and some people may have travel plans.
Sure.
If you allow us that flexibility, we will certainly try and get people in, witnesses in earlier if we're able to. But, we're thinking the 27th, but if we can get people in earlier, then we can start earlier. Thursday of next week is the 22nd.
Your Honor, perhaps if you advise them of the 22nd.
No, it's the 22nd.
Well,
Thursday's the 22nd.
I mean, these people have been extremely patient. I just don't want to say, come back on the 27th. And not, is there a reason why I can't have you all rest today and call up with your client later? I don't know who the who's the point person?
That's fine, Judge.
never mind, Your Honor.
We're okay.
Okay, so I'm gonna bring them in. October 5th is a court holiday.
So Your Honor, so the 27th,
Okay? The
if
20,
we could start then, if you could advise the jury the 27th, please.
okay, so I know no one, obviously, nobody knows how long exactly something's gonna take, but you said you think your rebuttal will be approximately a week?
Yes.
Okay. So,
I emailed you, Jay, I do have a doctor's appointment on the 30th of September at like 11:30. I don't know whether, I mean, I maybe could get back by 1:30 to do an afternoon, but.
That's okay. Is that, that's a Friday?
Yes, ma'am.
So we could start at 1:30, you think?
I would hope so. It's at Broward, which is right here, so.
Like any other doctor's appointment
I know.
at Broward. He says 11 or something, 11:30?
11:30.
All right, so. Okay, do you all think it would be prudent to estimate that the state will begin presenting its rebuttal on the 27th? We'll go through the 28th, 29th, the 30th will be a half day. And then the 5th is a court holiday with the estimation that the state would finish its rebuttal by October 7th, which is a Friday. Do you think that would be a reasonable estimate?
I think that's reasonable. We will try to do that.
Okay, and then, so I can tell them that we anticipate closing arguments being the week of October 10th?
Okay.
Am I forgetting something? And I know jury instructions and that will take a while, but if I can just give them that estimate, do you all think that's accurate? Or as best as it can be? Ms. McNeil?
Yes, Judge, we'll be ready to close after the arrest.
Okay. Okay, so what I'm gonna do is I'm gonna prepare these orders for the jurors. It's gonna take me a few minutes, and I'm going to prepare a tentative calendar with the dates before they come back in. And then the defense will rest, and then I'll excuse the jurors. And then we can come back later this afternoon if you want, and I can colloquy the defendant. Because you said that you want to get with the defense on that?
Yes, Your Honor.
Okay, is that acceptable to the defense?
Yes, ma'am.
All right, give me just 1 second. Actually, I'm gonna need about 15 minutes to do this. So we can be in recess until 10:45. We are in recess.
wanting to colloquy him as to other things too, like the fact that he's not gonna take the witness stand and all of the normal
Yes, Your Honor.
things that you would, when I say normal, I mean in a non-penalty trial, in any criminal trial, all of the things that I would go over with the defendant. I sort of hadn't thought of that, because there's specific things that go to a penalty phase. So that's fine, we can come back on Monday, what times?
Monday afternoon?
That would be perfect, Monday at 1:30.
Thank you.
So we'll put that on the docket, and that gives us time so all of the staff can be ready. So, just while we're waiting, I believe what we said, now that I've written it out on the calendar, is that you all will close and they'll start deliberating the week of the 10th, barring any unforeseen circumstances.
Hope so, yeah.
Okay.
For the, I don't know if I need to, when you serve the motion, should we send that to your email also, not just Nicole, or?
She is checking her email, but she doesn't technically have to because she's on medical leave.
Okay.
So why
You
don't
can
you,
send it
if
to
you
them.
can send it to me also, that would be great.
Your Honor, in an abundance of caution, and I know this sounds nitpicky.
Okay.
But, having the defense rest before the defendant is colloquied is probably not the best procedure to follow.
Well, then why don't I do a general colloquy? Because I have to be able to tell these jurors why I'm excusing them on a Wednesday at 10:57 in the morning, and they're not coming back for 14, I don't know how many days it is, 12 days. Or they're gonna think that I'm just inconsiderate of their time.
We can list some witnesses.
We can, and if I could suggest, Your Honor, that there were representations made by the defense that there were going to be 80 witnesses called, and if you would kindly express that to the defendant. There was medical testimony, there were statements made and opening statements by Ms. McNeil regarding evidence that was going to be brought out that is apparently not going to be brought out. And we can go over the doctors and whatnot that were listed. We can go through that later. But I think it's really crucial that there's some colloquy with specificity now.
Okay?
Judge, may I just have 60 seconds to make an objection to the colloquy?
Sure.
I'd be relying on United States versus Jeffrey Vanderwalker, 141 F. 3rd, 1451. And essentially our argument is that there is no law supporting the fact that the court should question the defendant regarding his agreement with the defense decision to rest at this point. His constitutional decisions that he's entitled to make are whether to plead, whether to testify, and whether to appeal. But according to this case that I just cited, having the court inquire into strategic decisions made by the defense invades the attorney-client privilege and his right to effective assistance of counsel under the Sixth Amendment to the United States Constitution. Thank you.
Thank you.
And Your Honor, we're not trying to invade attorney-client privilege here. We're just trying to protect the record and protect the defendant's rights and make sure that we can go to the next step of these proceedings as what would normally be done, Your Honor. And this is done in every other case where we have a penalty phase and witnesses are listed and not all of them are called. In case the defendant is sentenced to death, this will come up on a 3.851 and we will be sure that the record is intact.
I agree. Mr. Cruz, please raise your right hand. Do you solemnly, actually, I already put you under oath this morning. So you're still under oath, do you understand that?
Yes, ma'am.
Okay, sir, your lawyers have indicated that you're going to rest your case That means that they're not going to call any additional witnesses. Have you had the opportunity to discuss this decision with your lawyers?
Yes, I have.
And have you had enough time to consider this decision?
Yes.
Are you comfortable with this decision? Is there any witness that you know of, either listed or not listed, that you feel needs to be called by your lawyer or lawyers that has not already been called?
No, ma'am.
And do you understand, we had a motion about your brother testifying, and his lawyer came, and we had a hearing on it, and based on your decision to rest, your brother's not gonna be testifying. Do you understand that? Do you understand at a later time, you can't come back and say, hey, my brother was supposed to testify? The courts are gonna tell you that you waived that right to have your brother and any other listed or non-listed witness testify in this matter. Do you understand? And do you understand you would have the opportunity to testify if you so chose?
Yes.
Do you understand by resting, you're telling me, Judge, I don't wanna testify in this case? And I will instruct the jury that they may not consider that in any way whatsoever, because that's your right under the Constitution. However, I need to make sure that you are comfortable with that decision. Are you comfortable
Yes,
with your decision?
Yes.
Has anyone threatened or coerced you into making that decision?
No, ma'am.
And you've had an ample time to discuss your lawyers, the pros and cons of all of your decisions that you're making here with them today?
Yes, ma'am.
And do you feel that they've included you in these in the decisions that are specific to your case?
Yes, ma'am.
And Your Honor, if I could, just
Sure.
take a few minutes. The state filed a witness list. The defense, in doing their witness list, said they would be filing, or they would adopt any witnesses on the state witness list, and that's already part of the record. But if I could read off these witnesses, I know it will take a few minutes, but I think it's time well spent.
Actually, the names, and you can read whatever names, but you should know that the names of the potential witnesses that the defense was very adamant about me reading was an upwards of, what, 2,000 names?
Yes, they were read at the beginning of the case, but this is the defense witness list, and there's not 2,000 on here, but if I could.
It's a more specific
Yes,
list.
Your Honor, if you would just indulge.
Absolutely. Mr. Cruz, you're listening, right?
Yes,
You
I
look
am.
like you're listening, I just need to make sure. Okay, the state's gonna read off the witnesses. Please pay attention, because if there's any name of a person that you may not realize right now wasn't called, or you may not have thought about it, and you may say, wait a minute. And if you need additional time to speak to your lawyers, if you need additional time to think about it, you let me know, okay?
I will.
All right, thank you. Whenever you're ready, Ms.
Okay, thank you. Deborah Gray, Kevin Aaron, Dr. Richard Adler, David Augusti, Victoria Alvarez, Albert Anderson, Richard Anton, Jessica Appel Quintoni, Ted Arboleda, Justin Augustus, George Austin, Dr. Lisa Avery, Geraldine Avila, Ashley Baez, I'm sorry, she was a state, Baez, she was a state witness, Sherry Valagarian, Janine Scott Varela, Julian Barrion Nuevo, Paul Battaglia, Clover Bedway, Brian Behan, Melissa Belizaire, Regina Bello, David Belzar, Ben Benight, Dr. Pradeep Bihai, Jared Biedel, Dr. David Black, Dwayne Black, Kirk Blackson, Kathy Blaine, Cameron Blanchard, Rebecca Bogart, Tara Bone, George Bonilla, Elliot Bonner, Dr. Natalie Novick Brown, Jonathan Brown, Frank Bulgar, Timothy Burton, Vanessa Burton, Alfred Butler, Christopher Caldwell, Lisa Campbell, Giovanna Cantone, Ina Cantone, Francis Copray, Corey Corbacci, Juliana Carrion, Dr. Wesley Center, Scott Champagne, Leonard Charla, Graciela Chervurinsky, Eric Chang, Brian Childs, Dallas Chisholm, Moises Cobo, Amy Cohen, Dr. Deborah Collins, Roberto Colon, Heather Connor, Deborah Cooper, Dana Craig, Christian Crawford, Danielle Crawford, Anna Crean, Zachary Cruz, Jeffrey Curtis, Zachary Davies, Felice Winston Davis, Kim Davis, Tanisha Dawkins, Jessica DiCarlo, Jack DeSheen, Nicholas DeFrocia, Nicholas DeGiovanni, Anna Del Barrio, Rick Delgado, Dominic DiMartino, David Dittman, Ian Doriot, Brian Doherty, Marianne Dubin, Anthony Dubois, Hunter Dubois, Camille Dumornay, Edward Eason, Elia Eastman, Gregory Edlund, Sharon Ehrlich, Christopher Fahey, Kevin Fanti, Amin Faraj, Jeffrey Fadouk, Augustin Thelman, Derek Fernandez, Todd Fitzgerald, Cammie Floyd, Erin Foley, Latanya Bondren, Walter Foster, Jason Foddy, Cliff Fromer, Carlos Gambino, Pam Gallen, Anthony Garcia, Destiny Garcia, Gerard Garcia, David Garifi, Georgia Garnecki, Marnie Garvey, Alfred Garris, Marcy Geller, Angelica Gilmartin, Emily Goldstein, Carmen Gonzalez, Lee Gordon, Louis Gordon, Sharia Green, Sarah Greenberg, Kyle Green, Kelvin Greenleaf, Raziel Gertie, Joel Gardino, Zachary Gorino, Alyssa Gomez, Trajan Guntas, Kervins Gustav, Mary Hamill Field, Georgette Ham, Jeff Heinrich, Mina Vierholzer, Megan Hill, Dwight Hodgson, Richard Hoffman, Laurel Holland, Heather Holmes, Dr. Heather Holmes, Dr. Toby Sue Hope, Germano Torres, Walter Howard, Nicholas Uricchio, Erica Polajenko Irohita, Kathy Jackson Hunsucker, Brittany Jacobs, Susan Jacobson, Alicia Hamarillo, Stephen Johnson, Hank Juntunen, Anthony Katsikis, Rona Kelly, Michael Kenny, Robert Kenny, Philippe Khalil, Francine Kierman, Stephen Kaminsky, Michael Kratz, Kimberly Krozik, Krista Kreminski, Timothy Langolier, David Lara, Michael Leonard, Amanda Levison, Michael Leeds, Antonio Lindsay, Bruce Link, Ross Lobatin, Martha Luthen, Jamie Lyons, Christina McDonald, James McLean, Lucas Magel Case, Peter Mahmood, Tanisha Mayton, Ariel Maldonado, Luis Marchese, Sarah Margolis, Michael Matenzo, Chris Matthew, Nicholas Mazzell, Stephen McCutcheon, Christopher McKenna, Andrew Medina, Aloisi McKinday, Joan Menke, Eric Mezia, Timothy Metz, Nicolette Michiota, Robin McCow, Alexa Meadnick, Brad Mock, Gail Monahan, Gil Monson, Richard Moore, Dorothy Moore, Jacoby Moore, Jeff Morford, Carlos Mufti, Scott Myers, Amy Nast, Matthew Navratil, Kevin Nitch, Barbara No, Ryan O'Malley, Roger O'Prey, Nirma Ortiz, Karina Osio, Joseph Parsons, Valerian Perez, Georgie Pacheria, Scott Peterson, Vincent Peterson, Joel Phillimore, Jeffrey Podwika, Cripps Paulyard, Winfred Porter, Records Custodian of Palm Beach County Sheriff's Office, who's unnamed, Denise Reed, Dione Reed, Jomi Reed, Sandra Rennie, Christina Reyes, James Reyes, Philip Reynolds, Reed Ricard, Stephen Robson, Juan Rodriguez, Justo Rodriguez, Mark Roge, Lauren Rubenstein, Ania Sabadini, Jody Sampson, Melinda Sanchez, George Schmidt, Michael Sipo, Daniela Shaw, Stephen Stinkoff, Lexi Smith, Madeline Snyder, Dr. Lawrence Steinberg, Christian Swinson, David Taylor, Gerald Tourmaine, Marie Michael Delburn Pope, Joanna Bowles, Michael Wagner, Kelly Walker, Stephen Wexler, Brian Wilkins, Clint Williams, Joshua Willis, Felice Winston Davis, Christopher Worth, Billy Ray Woodard, Chance Woodard, Jacob Zalka, Eric Zamora. Anyone else? And those are the witnesses, Your Honor, that the defense has chosen to forego, and that it should just be on the record that those witnesses were listed and they have chosen not to call them.
Okay, Mr. Cruz, I saw that you were paying attention when the state was reading the names. Those names were also read by me to the jurors. Are there any of those people that you feel need to be called before you rest?
I don't know who those people are. And I trust my lawyers.
I'm sorry?
I don't know who those people are, and I trust my lawyers.
I can't hear the second part.
I said, I don't know who those people are, and I trust my lawyers.
Well, you know who Zachary Cruz is,
Yeah, that's my brother.
and there was, what was the,
Richard Moore.
you know Richard Moore.
Those are pretty much the only two people I recognize.
Well, you've heard Dr. Heather Holmes because we've litigated, I don't know, every single day. You know Dr. Holmes.
I believe so, yeah.
Okay, and you know, obviously the doctors who evaluated you, you know those doctors, correct?
I don't know their name.
Okay, but you would know, you know who they are. You could say, the doctor with, you know, the mustache who came in and asked me X, Y, and Z, why aren't you calling that doctor? Even if you don't remember the name, you know who the person is, correct?
I believe so, yeah.
Okay, so is there any doctor that you met with or any doctor that you recall that you feel needs to be called in your case?
No, ma'am.
And many of those were BSO deputies. Is there any BSO officer that you feel needs to be called that hasn't been called?
No, ma'am.
So there were doctors, there were BSO deputies, there were,
Civilians, Your Honor.
I don't know the context of the civilians because I'm not privy to all of the discovery like you all are, but.
And Your Honor, these are witnesses that the defense has had investigators work up this case. They have vetted the witnesses, chosen who to put on their witness list. They've made a strategic decision at this point to as to what witnesses were effective in front of the jury, and assumably they've done this to make an effective presentation, and it's their decision to rest at this time.
Okay, so here's the bottom line, Mr. Cruz. I understand you don't remember all those names because I don't remember all of the names.
And Your Honor, if I could interrupt for a
Sure.
moment. If the defendant would like to take a moment and speak with his lawyers, if he has any questions about any of the names that I have read off, that's agreeable to the state.
Sure. I'm just gonna, give me 1 minute and I will do that. So, Mr. Cruz, even though you don't maybe know the person by name, if there's any person that you remember either meeting with or talking with your attorneys about, anything to that effect, you could always describe the person to your lawyer, as in what happened to this person or what happened to that person. Is there any person that you recall being listed as a witness or having met with or having discussed that you may not know their name, but you know who they are and you feel that that person needs to be called?
No, I think we're good.
Okay, so I'm gonna give you a few minutes to speak to your lawyers in private, okay, so you can make absolute sure. Could you go to the right, my son, please? I didn't realize that. Sure, we can wait.
Thank you.
Do you all want more white noise? Do you need additional white noise? I saw that Ms. McNeil went back to her seat, so I assumed you were finished, but,
We're done,
Okay.
thank you.
Your Honor, I'm sorry, there's just one more individual that I want to make sure that the defendant didn't want called. It was Dr. Andrew Newberg. He would have presumably testified as to the PET scan findings. So just want to be clear, he was not on the witness list that we read, but want to be sure that that is someone that the defendant does not want called, and he's had that discussion with his lawyers.
don't you want me to wait for Mr. Marcus?
I think that if the defendant wants to have a conversation with his lawyers now, we can utilize this time for white noise.
Okay, there's a doctor that did a PET scan of you. Do you want time to discuss with your lawyers why that person is or is not being called?
No, I think we're fine.
Okay,
Thank you, Judge.
sure. Okay, is there anything else that either side thinks that I need to ask Mr. Cruz that I have not already asked him before I make my findings?
No, ma'am.
Okay?
No, Your Honor.
Great. I do find that Mr. Cruz is making a knowing, intelligent, and voluntary waiver of all of the rights that I've gone over with him. I believe that he has made his decision with the advice of counsel, and that he has participated in this decision based upon my own observations as well as his answers. At this time, is there any reason why we can't bring the jury in?
No,
State
Your Honor.
defense?
No, ma'am.
I'm also going to give them, I'm going to remind them that when they begin deliberating, they're going to be sequestered. And I'm not gonna go into great detail other than that they're going to be staying at a secure location, perhaps overnight with the sheriff's office, so that they should be prepared the week of the 10th to begin that process. Obviously tentative, which is a tentative week, but just to remind them in case, I don't know, if they make an appointment in the evening after we would normally be finished with court, to let them know that they're gonna have to be available perhaps overnight. Okay. Bring them in. everyone else may be seated. Good morning, ladies and gentlemen. I apologize for keeping you waiting. So I have what I think might be good news, depending on how you receive it. Hopefully, I think you all will find it good news. Actually, I jumped the gun a little bit here. I jumped the defense, call your next witness. I apologize.
Your Honor, at this time, the defense rests.
Okay, now the news is out. So I can finish what I started to say. The defense having rested its case, the state now has the opportunity to present what is called a rebuttal case. That is not going to happen until September 27th. It's impossible to anticipate from either side exactly which witnesses may or may not be called. It often depends on how things go, and the attorneys have the ability on both sides to perhaps call a witness or not call a witness, or sometimes witnesses' testimony takes longer or shorter, as you all know. So we did not anticipate that the defense would be resting today, therefore the state is not prepared to go forward with the rebuttal case until the 27th. That is nobody's fault. It's my fault. So if you need to blame someone, please blame me. Things happen throughout the course of the trial, as I'm sure I told you in jury selection. Sometimes things go quicker than we expect, and sometimes they take longer. So again, any scheduling problems, any delays, please blame me. Don't blame the lawyers. It's not their fault. It's my job to keep things running efficiently and to try to estimate as best as I can how long things will take. So if I'm off, it's my fault, and I apologize for that. So if you see your calendars that I've put on your seats, the reason we're not starting on Monday the 26th is because it's a court holiday. And the courthouse is closed. So we're going to start on the 27th. The state anticipates that its rebuttal case will take approximately 1 week. However, because there is a court holiday on Monday, September 26th, we will have the full day on the 27th, a full day on the 28th, a full day on the 29th. Then I have legal matters that I need to go over with the lawyers. There are a lot of steps that you all don't see that have to take place during a trial. Unfortunately, I can't get into all of them, but please do understand that everyone here, especially the lawyers, are working very, very hard to make sure everything is presented in a continuous manner, not to we're not going to the beach on a half day when we don't start till 1:30. We're not at the spa. I promise you that. These lawyers are probably exhausted because they have worked very, very hard on both sides. And I commend both sides for that. But I just want you to know, when there's half days, it's not that we're doing something that's not work related, because we all are working very hard. Okay, so that Friday, we're gonna start at 1:30. That's the 30th. Then if you move to October calendar, there's another court holiday, another Jewish holiday on the 5th of October. It's Yom Kippur. So we can't be in session, even if some of you may not celebrate that particular holiday. The courthouse is closed, we cannot be in session. So because even though the state anticipates that their rebuttal will take a week, because we have a court holiday smack in the middle of both of those weeks, and then we have a half day, I'm anticipating, and again, things happen, as you all understand, thank you for understanding. So we believe the state's case will be finished on Friday, October 7th, which means the following week, the attorneys will present their closing arguments. I will instruct you on all of the law, as I promised during jury selection, and if you remember or not, I'll remind you not to worry. You'll be given the instructions in writing, and I will go over the instructions in depth with you. Then, you will begin deliberating. And the reason that I'm bringing that up is because in a capital case, in this case, you will be sequestered. Now, we went over this in jury selection, but just to remind you, and I'm not going to get into it in detail today because the sequestration, we call it the sequestration packet, is very, very detailed. I'll just say that. But in general, once you begin deliberating, you don't have contact with anyone other than your fellow jurors until you reach a verdict. So we will, whichever day that this falls on, in other words, whatever day the attorneys finish closing arguments and you begin deliberating, if the arguments are finished, let's say at 2 o'clock in the afternoon, we won't begin deliberating because you have to be sequestered until the following day. So we'll begin whichever day that falls on at 9 o'clock in the morning, and you will be sequestered. If your deliberations take longer than a day, which they may not, I have no idea, there's no way to tell you that in advance. Many times they do take more than a full day. Then you will be taken to a secure location by the sheriff's office. You'll feel like you're, the President of the United States, just like you did when we went on the jury view. I don't know if you felt prestigious or very, I know I did, because there was sheriff's office everywhere. They walk you everywhere. They go with you everywhere. It's I feel quite an honor. And they stay with you. They drive you. They do everything for you. They take you to a nice hotel. I don't tell you the name of the hotel because it's absolutely secure. Nobody knows where you are except for you all and the sheriff's office, and that's done so that nobody would ever try to influence you or bother you, or it's just an absolute secure, secret process. So that's kind of exciting. You're going to go to a secret hotel. It will be a nice one, and you just will have to guess. Because I won't tell you until you won't know until you actually arrive there. During that process, you will be given very limited time to speak to your family on the phone. All calls will have to be monitored by the sheriff's office. You'll each stay in your own room. You will eat together, but when you go into your rooms at night, it's a very, very secure process. There's security, there's screening, there's very limited number of things that you're allowed to bring with you. They even limit the alcohol intake, believe it or not. I think it's 2 drinks a night if you so request, but everything has to be approved by the sheriff's office. And that's for the purpose of keeping everything absolutely fair and absolutely secure. So I will go over all of that with you, but please, if you have any appointments in the evenings, the week of the 10th, please understand that you're going to have to be available 24 hours a day from the time that you begin your deliberations. I'll answer all of your questions well in advance, like as far as packing, and I'm sure you have many questions. That's normal, and I promise I'll answer all of those and give you very specific details, but I just need to make sure that you all understand the week of the 10th, you're going to be sequestered, you're going to have limited contact with your family, and you're going to be together all the time. Okay? Other than that, I have to, because of the extended period of time that we're going to be away from one another, I do need to read you the instructions that I have read to you many times, but I'm going to read them in full. And I would ask that even though you're probably thinking, oh, come on, Judge, I've heard this a million times, please listen carefully, just in case, on the off chance that there's maybe one small thing that I didn't tell you or that you didn't hear. Please listen carefully. During recesses, which is going to be from about 10 minutes until September 27th, you must not discuss the case with anyone. And your friends and family may be very curious because your job is one that is very, very highly publicized. In other words, not your names or your faces, but there are many people that are very curious about what's going on in here. So please do not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. On the off chance that you're at Publix or wherever you may be, and someone attempts to say something to you or in your presence, again, tell the person to stop and immediately report it. And again, when we're in recess or on the weekends, you can call my assistant, leave a voicemail. I will get it right away and we will take care of it. This case must be tried by you and only you on the evidence presented during trial. You cannot conduct any investigation on your own. So absolutely, under no circumstances should you do any research. You can't say, you know what, let me drive by the school because there's something that I may have missed. Absolutely not. You cannot do research. You cannot drive to these places that you've heard about, even though you've already been there. You may say, well, what's the big deal? We've already been there. No, you can't do it. You may not do it. If you do, it could cause a mistrial, which would be terrible because we'd have to start the whole process over. This includes reading newspapers, watching television, using a computer, a cell phone, or the internet, or any electronic device, or any means at all to get information related to the case or the people and places involved. For example, I'm just going to throw this out there. Maybe you've determined that, well, you didn't realize this, but your neighbor has information about the case. No, you can't even talk to your neighbor. You cannot talk to anyone. You cannot get information by any means whatsoever. The only thing you get is what you get in this courtroom or when this court is in session, like we were at the school. That's considered a court proceeding. You must not visit the places mentioned or use the internet or maps or pictures to see any place discussed during the trial. Now, of course, anything that's in evidence, you'll have the opportunity to review in depth or not at all, whatever is your preference, but that is not till you begin deliberating. One other thing I just want to mention, there are many news sites, which you should not be on, which play live, and you can, these proceedings are being videotaped, and there are many news stations and sites that play the proceedings over and over again in certain parts of the proceedings. Do not look those up, and certainly you should not be posting on those sites. You shouldn't be on them at all, but don't post. If you have Instagram or Facebook or, I don't know, there's a million different, Snapchat, I think that my daughter uses, I don't know. But don't go on there and try to look up anything about the case, okay? And if something pops up in your feed, delete it, exit out, that's on you, okay? I know you all take your duties very seriously because I can tell the way you concentrate and listen when I'm talking, and I very much appreciate that. I appreciate you taking this serious. I appreciate you all working so hard and being so diligent as a group of jurors. You've been wonderful, so let's keep it that way, please. Other than that, you have an order that was on your chair, the ones that I provide you each week, that indicate when you were here for jury service and when you are required to return. You all have phone numbers. I think you're all very familiar with, you've been great about updating the staff when you have a personal situation going on. Thank you for doing that. As I hope you have been able to see so far, minor schedule issues, we can accommodate you to the best that we can. So please continue letting the staff know when you have an issue. And other than that, does anyone have any questions? Not about any of the testimony or evidence, but about the procedure or what happens next. Okay, so this is the part where I get to the good news. The good news is, I told you during jury selection we wouldn't be finished till the end of October, although that's still a possibility because you never know. It looks like it's going to be more like mid-October, so we're running a little bit ahead of schedule, so that's good news. And the other good news is you now don't have to come back here and see us until, or see me until the 27th of September, and you get to leave early today. So I hope you have a wonderful week and a half off. Again, thank you for your patience. If I had known earlier that this was going to be happening, I would not have dragged you all in here. Again, that's my fault. So please understand that we are all working hard and doing our best, as I know you are. Is there any questions? Okay, thank you. Bye. Okay, the jurors have been excused. Is there anything that we need to address before Monday at 1:30?
Well, from the state, Your Honor.
Nothing from the defense.
I mean, what a great group of jurors. They didn't even hesitate when I told them they needed to pack a suitcase. I mean, I think that's a good sign. They take their job very seriously, so I'm very happy with that. All right, we're in recess. Thank you all very much.
Thank you, Your Honor.
See you.